Have you ever received a notice of debt collection via email? Okay, well, if you haven't, I have. Okay, and I actually just got one just recently. And this is what we're going to talk about today. We're going to talk about when a debt collector sends you a notice of their attempts to collect the debt via email and how the FDCPA, how Regulation F can help you with fighting back. Okay, so this was sent to me. This notice of debt collection was sent to me on the 3rd of October. This is my personal information here. I've crossed out some things, but I just want to show you guys for educational purposes only, okay, and informational purposes only. So this was sent to me via my old business email address, okay? And the reason why I want to talk about it is because when it comes to these debts and these debt collectors reaching out, so it doesn't matter if you owe the account at all. It's not what it's about. And even still, if the account is something that you owe, this isn't a video for you to get out of paying what you owe. What I'm saying is that when a debt collector is coming after you to collect a debt, they must follow proper procedures and also processes in their attempts to collect on a debt. They can't go around violating our rights in their attempts to collect the debt, okay? So like I said, I received this notice and it actually came through my old business email address. Mind you, I've never communicated with this debt collector before via email. I have no idea who this debt collector is. The creditor who transferred this account over to this debt collector, I've never communicated with this creditor via this email address. I've never given them permission to provide my email address to a debt collector. None of these things whatsoever. And what's important about that is because what the law states about how a debt collector can communicate with you and things that a creditor must provide to you if your email address, if they are providing your email address, and not only just your email address, your phone number as well to a debt collector, okay? But this is what the notice look like. If you've never received a notice of debt collection, this is usually what the notices look like. It'll tell you information about the debt, give you information about the company. It's important to read these notices because there's a lot of information that is in here and a lot of information in here that you can see find violations real quickly. Um, but I just kind of cut and pasted some sections just to show you guys. But it tells you this email was sent to it. It provided my email address. If you no longer wish to receive these emails, you may unsubscribe at any time. Well, I never subscribed in the first place, so I'm not going to unsubscribe to something I never subscribed to in the first place. There's clickable links that were in here that'll take you directly to the debt collector, to their website. Me, I do not communicate with the debt collector. If they send me something via email, I'm not going to respond to them back via email because, like I said, I've never provided you any consent to communicate with me in the first place via email or any other method. So I'm not going to communicate back with you via email. But I did send a letter over to this company. Let's go to the FDCPA, okay? Actually, we're gonna go to Regulation F. And you can get to Regulation F basically, but you can just go to Google and you can type in Regulation F, or you can type in 12 CFR, and we're going to go to it's part 1006. Okay, so when you get here, this is where you see all the information, and it's so important, y'all, to go read this information. There's a lot of information here. I know when we go read the FDCPA, there's a lot, but go read Regulation F. It breaks down things so thoroughly for you, okay? But we're going to go down to subpart B, okay? Because this is where it speaks about the debt collectors and their communication, the rules for communications in connection with debt collection. So we're under subpart B, 1006.6, where it speaks about the communications, goes into more giving you definitions, and then things as far as what things means, because it's important to know what it means. So you'll know what your party is as a consumer, what their party is as a debt collector. So we're going to scroll down to D because this is where it speaks about communications with third parties. And under D, it says prohibitions, and tells us, and these are except as provided in paragraph D2 of this section, a debt collector must not communicate in connection with the collection of any debt with any person other than, and they tell you the only people that the debt collector can communicate with: the consumer's attorney, the consumer reporting agency if otherwise permitted by law, the creditor's attorney, or the debt collector's attorney. Then they give us the exception, and these are things that does not apply when a debt collector communicates in connection with the collection of any debt with a purpose. And they tell you that information there. Then we get into reasonable procedures for email and text message communication, okay? A debt collector maintains procedures that are reasonably adapted for purposes of FDCPA Section 813C to avoid a bona fide error in sending an email or text message communication that will result in a violation of paragraph D1 of this section if those procedures include steps to reasonably confirm and document that The debt collector communicated with the consumer by sending an email to an email address described in D4, which we're going to read next, of this section, or text message to a telephone number described in paragraph D5. So if you're dealing with a debt collector that's been texting you, you want to make sure you're reading this. The debt collector did not communicate with the consumer by sending an email to an email address or a text message to a telephone number that the debt collector knows has led to a disclosure prohibited by D1 of this section. This is where we get into the procedures for an email address. For purposes of paragraph D3I of this section, a debt collector may send an email to an email address if, and then they give us the procedures based on communications between the consumer and the debt collector. Me being the consumer, National Recovery being the debt collector. The consumer used the email address to communicate with the debt collector about the debt, and the consumer has not since opted out of the communications to that email address, or, because we got options here, the debt collector has received directly from the consumer prior consent to use the email address to communicate with the consumer about the debt, and the consumer has not withdrawn that consent. So I've never used this email address to communicate with this debt collector about this debt. So there was no need for me to opt out. Not only that, the debt collector has never been provided any type of consent from me to use this email address to communicate with me. All right. So there was no need for me to withdraw consent. Consent was never provided. Then, or procedures based on communication by the creditor. So now this is what we get into the creditor. This is the one who they're collecting on behalf of. A creditor obtained the email address from the consumer. I've never provided this creditor with this email address. Like I said, it's my old business email. The creditor used the email address to communicate with the consumer about the account, and the consumer did not ask the creditor to stop using it. They've never communicated with me about this account via that email address. Before, and this is a big word, y'all, before the debt collector used the email address to communicate with the consumer about the debt, the creditor sent the consumer a written or electronic notice to an address the creditor obtained from the consumer and used to communicate with the consumer about the account that clearly and conspicuously disclosed. So that's important, because prior to this debt collector contacting me via email, a notice should have came out to me from the creditor. And this is where the Regulation F tells you about what that notice should disclose, okay? Clearly and conspicuously. One, that the debt has been or will be transferred to the debt collector. So you have to provide me with a heads up. The email address and the fact that the debt collector might use the email address to communicate with the consumer about the debt. That if others have access to the email address and it's possible, it may be seen. So if someone else has access to your email address, they may see the information, of course, if they have access to your email. Instructions for a reasonable and simple method by which the consumer could opt out of such communications, and the date by which the debt collector or the creditor must receive the consumer's request to opt out, which must be at least 35 days after the date the notice is sent. The opt-out period provided under D4 IC or 2ICF, C5 of this section has expired and the consumer has not opted out, and the email address has a domain that is available for use by the general public unless the debt collector knows the address is provided by the consumer's employer. So these are all the things and procedures that a creditor must do. So if we have this debt collector, and I've already made contact with the debt collector, and I'm waiting on a response back. But if they were to come back and say, well, the creditor provided this information, and mind you, I've already reached out to both the debt collector and also the creditor. I'm waiting on responses back, because I want information about this notice. Now, mind you, I already know I've never communicated with them. So I want them to give me information about this notice that should have been sent out to me prior to this debt collector contacting me via email address. Also, I want a log of that information as well, because if I've ever communicated with the creditor, then there should be log, there should be emails. So I want that information from that creditor where we've communicated. I want copies. I want the consent. Show me where I provided you consent to communicate, not only the creditor to communicate, but also that debt collector, where I've given you consent for that debt collector to reach out to me, and where consent was provided for you to contact me. So, but also, like I said, that notice, I want to know, when was that notice sent out to me? Like I said, I've never given any consent, but these are just questions that I'm going to ask, because I'm going to create a trail, and I need that information and documentation to make sure that, when you're going after them, because we have a violation, and we have a violation of the FDCPA, and that is where we have funds that kick in. We have money, redress, all of that kicks in. And not only under the violation of the FDCPA, but also we have state laws as well. So if I was to decide to take this to court, then there's other, ways other avenues to collect um, from this debt collector. But also we have procedures based on communications by the prior debt collector. So we know that when it comes to debt collection, accounts are transferred and sold all the time. So if we're dealing with a debt collector like myself that's dealing with a debt collector who may try to claim that a prior debt collector, they obtained the email address from a prior debt collector. There's procedures for that as well. So any prior debt collector obtained the email address in accordance with paragraph D4I or of this section. The immediately prior debt collector used the email address to communicate with the consumer about the debt, and the consumer did not opt out of such communication. So that's not the case for me. I've never communicated with any debt collector about any prior debt collector about this account or anything of that sort. But that's also a thing that you want to be aware of in case that is something they try to come back with. Okay, so now we need to have that information provided as well, logs of that information, that consent that was provided, all of that, or the notices sent out to me that were clearly and conspicuously where I can opt out, all of that information that we want um, to receive. Okay, so if this is something that has to, if it has to be taken to court, then I'll have all my information that I need from this debt collector and also from the creditor. So I've already reached out to both and informed them of these violations and the things that I want from them. And if I don't get, what's next. Okay. But yeah, make sure that you're going back and reading Regulation F. Make sure that you're understanding the FDCPA. If you are dealing with a debt collector that has reached out to you and violated your rights, because they can't just go around violating our rights in their attempts to collect the debt. Because even if it is an account that is owed, that's fine, but you cannot violate in the process to collect the debt. Okay, because now what you've done is now it's going to cost you more because you violated the FDCPA than what the debt is even worth. So, but this is why we have to start getting those understandings of where we have been harmed and where the violations occur. Okay, and there's more too. If you have a notice, there's more information on it than this. I just cut and pasted some things from the notice just to give the main portions of it. But when you have one, you make sure that you go through all of it. And like I said, if you're dealing with a debt collector and you've been violated, have that understanding. This one has not hit my credit report. And I swear if it do, oh, if it do. But this is not on my credit report. As soon as I got this notice through my email address, I made sure I responded right away and kept documents and keeping copies of everything. I did not respond to them via email because, like I said, I've never given them consent to communicate with me via email, and I'm not going to start. So I did everything in writing, and that way I can have my paper trail. Okay. All right. But I hope that this helps y'all. But I'll keep you guys updated on what happens, and yeah, we'll see. All right, y'all. Good luck with everything.